I got multiple lawyers standing up. Who's first?
I'll go first, Mr. Chairman. I just wanted to alert the Commission. We have prepared late filed Exhibit 152, which was done at the request of Commissioner Elam. So that's been passed out to the commissioners as well as the other parties of record. Mr. Rooks was excused yesterday, and we're going to pass the baton to Mr. Pruitt, and he'll be able to answer any questions related to that exhibit.
Thank you. All right. Mr. Reed.
Thank you, Mr. Chairman. Joe Reed on behalf of Dominion Energy. At this time, Dominion recalls Prabir Pruitt to the stand. Mr. Pruitt, are you the same Prabir Pruitt who provided testimony before this commission earlier during the course of this hearing?
Yes.
And are you still employed by Dominion Energy as its Director of Mergers and Acquisitions and Financial Analysis?
Yes.
Have you prepared or caused to be prepared under your supervision second supplemental rebuttal testimony of 13 pages that was previously filed with the commission in this docket?
Yes, I have.
Do you have any changes or additions to that document?
No.
If I were to ask you the questions appearing in that document here today, would you provide the same answers?
Yes.
Mr. Chairman, at this time, I would move that the pre-filed second supplemental rebuttal testimony of Prabir Pruitt be read into the record as if given orally from the stand.
The second supplemental rebuttal testimony of Prabir Pruitt will be read from the record as if given or will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Pruitt, have you prepared or caused to be prepared under your supervision for exhibits labeled as PP1A, PP2A, PP4A, and confidential exhibit PP3A that were previously filed with the Commission as attachments to your pre-filed second supplemental rebuttal testimony in this docket?
Yes.
Do you have any changes or additions to those exhibits?
No.
Mr. Chairman, I would at this time move into the record as the next composite hearing exhibit the public exhibits attached to Mr. Pruitt's second supplemental rebuttal testimony labeled PP1A, PP2A, and PP4A.
Those exhibits will be entered as hearing exhibit 169.
Thank you, Mr. Chairman. And then finally, I would also move into the record confidential exhibit PP3A from Mr. Pruitt's second supplemental rebuttal testimony and ask that it be kept under seal.
And that will be entered as exhibit 170.
Mr. Pruitt, have you prepared a brief summary of your testimony?
Yes, I have.
Pass that out, and then I will ask you to deliver it. All right, Mr. Pruitt, you may proceed.
Thank you. Good afternoon, Mr. Chairman, members of the Commission. Thank you for the opportunity to appear before you again today. My testimony focuses on a revised proposal by the joint applicants called the Alternative Levelized Customer Benefits Plan, the Levelized Plan, or Plan BL. This levelized plan was prepared in response to calls by stakeholders, policymakers, and commissioners to consider a plan where the bill would be close to the experimental rate authorized by Act 258 and to suggestions by ORS witness Elaine Collin that the Commission adopt an approach in which customer bills are levelized over a 20-year N&D recovery period. Plan BL meets both these objectives while preserving our merger economics. Dominion Energy will close the merger under the terms of either Plan A, Plan B, or Plan BL. My testimony also includes a consolidated list of merger-related commitments proposed by the joint applicants. The levelized plan would reduce the typical residential electric customer's monthly bill to approximately $125.26, which is significantly below the $147.53 May 2017 typical customer bill, appreciably less than the approximately $137 bill under the originally proposed customer benefits plan, and less than the $126.96 bill under the alternative customer benefits plan. Importantly, as shown in Table 1 of my testimony, the Plan BL typical monthly bill is slightly less than the current experimental rates. Overall, the levelized plan provides an all-inclusive bill reduction of approximately 15% relative to May 2017 levels. What is levelization? Levelizing the NND recovery very simply takes the typical declining rate-based model, where recoveries and rates are higher in the earlier years and lower in the later years, and converts it to a more equalized recovery over time, much like a home mortgage. While this model is not conventional and requires an additional commitment by Dominion, we can make this model work in this instance through adjusting the customer refunds over 20 years. Like the alternative plan, the levelized plan achieved this lower bill by providing a total of $2.039 billion in refunds over a 20-year NND recovery period. The levelized plan also reduces the NND investment to be recovered to $2.768 billion from $2.772 billion, as requested under the alternate plan, to reflect excluded amounts related to senior management bonuses as addressed in the merger conditions. In addition to reducing monthly bills from their current levels under the experimental rate, the levelized plan has a superior net present value for customers compared to either Plan A or Plan B. It will result in customers paying $130 million less in nominal dollars over time than Plan A, than Plan B. And it will result in rates for SC&G, which are for the first time in many years very competitive with peer utilities and regional averages. In fact, the industrial customer rates will be well below the regional average. All of this is shown in the text and in Table 2 of my testimony. Also, in response to requests from ORS, I have included a list of consolidated merger-related conditions proposed by the joint applicants. These commitments are comprehensive and provide significant protections associated with the combination. There now include several proposed conditions based on comments from commissioners and other parties during this hearing, including Department of Defense and federal agency bill credits, extending non-executive employee pay protection until July 1st, 2020, consumer education program on benefits plan implementation, bill credits to SCE&G natural gas customers for refunds of 2017 revenues, open and transparent communication with the Commission and the ORS. Funds in the Rabbi Trust for senior management payments will not be included in any future cost of service. Senior management bonus payments charged to the NND project will be excluded from NND rate base and not included in future cost of service. Cost of the Bechtel report will not be included in rate base or cost of service. Timmerman consulting payments will be excluded from rate base and cost of service. Civil litigation defense expenses associated with the merger and NND abandonment will not be included in rate base and cost of service. And the president of SE&G will continue to be a South Carolina resident with his or her primary office in Casey. Thank you. This concludes my summary.
Thank you, Mr. Pruitt. Mr. Chairman, Mr. Pruitt is available for cross-examination by the parties or questions from the commissioners.
Thank you. Lawyer Guile.
Thank you, Mr. Chairman. May I defer my cross-examination to ORS? Let them go first.
Yes, sir.
Thank you, Mr. Chairman. We have late filed Exhibit 153. Jim, would you pass it out? 153 that shows from ORS the actual NND portion of each relevant plan, and then separately the tax reform savings. And I'll refer to that, but she has them already. So let's talk first about a few important parts of your testimony, your second supplemental rebuttal testimony, and the Plan B levelized terms and conditions. On page 5 of your supplemental rebuttal testimony, you point out the net present value to customers is $962 million for this new plan.
That's right.
And on the bottom of page 6 of your testimony, you say that Dominion remains open to moving elements of the plan around to optimize the plan for customers, right?
Yes.
Thank you. On page 10, you testify that your proposal on the Tax Cut Jobs Act savings fairly and equitably ensures that customers will get the benefit of federal tax reform going forward. But you can't be sure that it does that, can you?
Sorry, what page is that?
At the top of page 10, it's a question about preserving the economics of the deal for Dominion. The second full sentence, it says that our proposal on Tax Cut Jobs Act savings fairly and equitably ensures that customers will get the benefit of federal tax reform going forward. But you can't be sure of that, can you? Based on this new plan.
I don't understand why we can't be sure. Can you?
Well, it doesn't include all the tax savings, does it?
It does from our perspective and how we have calculated it. And I think witness Jim Warren, who was here a few days ago, he did explain that. All
right. Well, we'll get to that. And you testify a little bit farther down in that same paragraph after mentioning Mr. Warren that the ORS tax proposal would upset the economic balance of the customer benefit plans necessary to close the merger. And by economic balance, you mean Dominion's merger economics, right?
Economic balance as in the benefits to customers and the benefits to shareholders. It's an all-encompassing balance, not just Dominion itself.
Right, but the part about Dominion is what it gets from the customers, right? That's the economics of the merger.
Right, economics of the merger when we talk about, yes, but not the balance.
All right, and turning to page 12, I just want to point out, almost in passing here, that the bottom of page 12, one of the additional commitments being made yesterday or today that Dominion would protect customers only from civil litigation defense expenses associated with the merger and NND abandonment. But I thought you all had already committed to agree to protect customers from all litigation expenses from merger and NND abandonment. Is that right?
Can you point out where we committed that?
In response to us going through the indemnification provision of the merger agreement, 5.08 with Mr. Farrell, I thought he made it pretty clear that, one, he didn't think that provision actually did provide protection to SCANA executives for criminal investigations and fines and fees, although I think the language appeared to do that. But here, just the use of civil seems to stand out to me, and that's why I wanted to ask. And is this a change in what y'all's previous position was? And if not, I think we can move on.
Yeah, I'm not a lawyer. I can't comment on the details of how it is drafted. I think Mr. Farrell explained that in his testimony. I'm not an expert, so I can't answer.
But these merger conditions that you're presenting today, they're not a change in position on that particular term from what was previously agreed to by Dominion?
I would assume so.
Thank you. And we go to Exhibit 1 of your testimony, page 2. It's talking about the plan terms of the new plan. Paragraph 4 near the top, in the second sentence, I want to ask you a couple questions about the entire balance of SCNG's net operating loss carry forward and related deferred tax asset. You say it's approximately $0.6 billion inclusive of tax reform benefits, and that will be reflected as a rate base offset. First question is the entire carry forward could be more than $600 million that's being estimated there, right?
Sorry, I don't follow. The entire carry forward is more than the $0.6 billion. This is an after-tax number. Are you referring to the 1.5 and $2 billion we were talking about earlier?
No, just this sentence here that you're saying the entire balance of this net operating loss carry forward related deferred tax asset. You're saying in this sentence it's approximately $600 million. And you're using that to build this this rate that's 125.26, right?
That's right.
And the monthly amount actually could increase if this carry forward is more than 600 million, because this is a reduction to tax rate base, right?
Then the NOLC DTA, this is will offset the deferred tax liability. So it as we use the NOL over time, it decreases the rates, and we don't expect to be in a position where, based on our projections, where there will be a loss. I don't see how this number goes up over time.
But it's an estimate at this point, and it could be different than the 600 million you're using to calculate the rate, correct?
It is an estimate at this point, but as part of the plan, we would be okay using the 0.6 billion.
And if it's different, the rate could actually be different in the plan, couldn't it?
That's right. If we use a different number, the rate could be different, but we're agreeing to use 0.6.
And not the actual, whatever the actual tax savings are for that component.
Yeah, that's fair to say.
In the paragraph 5, right below there, the last sentence, you make clear that that's $32 million in financing costs for the transmission costs themselves that are being deferred is still in rates and will continue to be in rates in this plan, right?
The $32 million, yes, that's right.
And that's about $2 a month for the average monthly bill.
That's right. It's about $1.93 or 92 cents.
And if you, on the same Exhibit 1 to your testimony today, go to page 4, I want to ask you a little bit more about the tax savings. At the top of that page in paragraph 11, you talk about the tax savings to SC&G from the Tax Cut Jobs Act, and that's separate, obviously, from tax savings for the abandonment of NND, right?
That's right.
Dominion agreed that all tax savings would be subtracted from the monthly bills so that it's passed through to customers, and it's got to be done to show the NND portion, right?
Yeah, I think that's right. I think, but the analysis we did does both. So it's the benefit of the tax cut is passed on the base rates, is also passed through, which is a 2.7% we highlight here. In addition to that, it's approximately 1% of the bill on the NND portion. So we're passing both of them back.
And what we're going to look at in a second is the NND portion of a couple of plans and the tax savings for the Tax Cut Jobs Act, not abandonment, so that we can isolate the NND recovery. And you would have to subtract out this tax reform savings in order to isolate the NND portion of the bill, wouldn't you?
That's right. We'll have to isolate the base rate tax cut savings in order to see the NND portion. That's right.
A little bit lower in that paragraph, you talk about the one-time refund of tax savings for 2018 and how that goes back as a one-time bill credit, right, in year one?
That's right.
And so in 2019, that should result in a lower bill, right?
Compared to?
The year two, when there's no one-time refund.
Yeah, that's right.
And this one-time refund, as we heard from Ms. Griffin, is about $97 million, isn't it?
That's right.
But Plan B doesn't include that decrease in year one, does it?
No, Plan B and Plan BL both include the $97 million.
But the monthly bill isn't different for the first year when you've got an additional $100 million decrease in Plan B, for example.
Yeah, we're not including that one-time bill credit in our bill calculation, in our typical bill calculation. That is excluded from that. So the 97 is an addition, but it's a one-time thing, so we didn't think it was fair to put it in.
So the customers will actually get a much lower bill in the first year than what you're showing in the plan numbers?
Yeah, I mean, it is a bill credit. I'm not sure if it's going to last for the entire year. But yeah, I mean, the 97 is in addition to the numbers we're providing.
Thank you. So that'll be provided on top of what the plan rates are that you're showing?
I think so.
Thank you. And then for the ongoing tax reform, paragraph 11, if you add the two numbers together, shows that the annual tax savings from tax reform for the customer benefit plan is $67 million, right?
Yes, that's right.
But actually, in the alternate Plan B levelized plan, it's $87 million, isn't it?
On the base rates, I believe that the only difference between Plan B and Plan BL is how we're giving the $1.03 billion back. So in Plan B, the $1.03 billion is given back in equal payments over 20 years. In Plan BL, all we did was we changed the shape of that give back, where a higher amount is given in the years up front and lower in the back. That way, instead of a bill profile in Plan B that was flat for 10 years and then declining after that, it becomes flat.
Sure, and that's
the only difference.
Right, and that's how it works. But in this paragraph, you're talking about the annual savings on the base rate for the tax reform, nothing to do with NND, is $67 million, and that is the savings under your customer benefits plan. But I don't think that's the right number on the alternative Plan B levelized. I thought that number in your work papers was $87 million. And please correct me if I'm wrong.
I believe it's the same for both.
And which number is it?
67.
And so if your work papers show $87 million for that number, that's not right? Or maybe I read it wrong.
Yeah, I mean, I don't have the detailed work papers in front of me, but I believe it's 67 for both.
Okay, thank you. Let's talk just quickly about generally how you build a utility rate in this case. There's three components, right? You start with a non-NND base rate, right? Which without the $2 for transmission is about $120.40. Is that right?
Without transmission, you said?
Yes.
I think that's close. I don't know the exact number.
Right. I believe with transmission it's $122.43, and then if you back it out, it's in the neighborhood of $120.50.
Okay.
All right. And then, so that's the first step, is you got to start with the non-NND base rate. Then you're going to add the NND cost recovery, and that is the base rate minus regulatory liabilities, which is Toshiba guarantee and tax savings from abandonment. And then you multiply it times the rate of return, which is this average weight of cost of capital we've talked about. And then that's over the amortization period, right, of 20 years. And that's essentially how you build the NND portion of the cost recovery.
Just one difference in this case, what we're assuming the rate base approximately $2.8 billion. In Plan B, a little bit lower, right, 2.768. And then the rates are built based on that. What we do after that is we take the Toshiba cash and the additional $1 billion that add up to $2.039 billion. We give it back to customers over time such that it reduces the bills.
Is it fair to say that the main difference between the ORS plan and the Dominion plan is that we take it out of rate base before calculating the rates, and you put it in to buy down the rates after they're calculated?
If you just that component, yes. I mean, there's a lot of other differences. Yeah.
So the non-NND rate base, then you calculate the NND cost recovery, and the third and final piece of the rate in this case is the subtraction of 100% of the savings to SC&G from the Tax Cut Jobs Act tax reform, right?
That's right.
All right, let's take a quick look at what we just got. This late filed exhibit 152. You have a claim? You familiar with this?
Yeah, I'm familiar.
There's a couple of questions. This was, I think, provided in response to Commissioner Elam's request to SC&G. First, the same thing we just talked about, right? The 2.8 and the 1.2, that's essentially the rate base. We see the return on equity, but you use the entire rate of return, right? The average weighted cost of capital.
Yes.
And then 20 years, and you divided it among the rate customers.
Mm-hmm.
All right. And then number two is you didn't have any regulatory liability adjustments to that rate base, did you, in these calculations? You didn't further take out the Toshiba money, for example.
No, the rate base numbers are what is in the first or second column there, the 2.8 and the 1.2.
Right. And third, you didn't make any tax adjustments either, did you?
No, we did account for tax as in tax reform.
The Tax
Cuts and Jobs Act. We adjusted for that in these rates.
You think that these calculations include a subtraction of the Tax Cut Jobs Act after you calculated the rates?
Yes, that includes, this number includes the $67 million.
Did you do those calculations?
I have seen those calculations. I didn't do it.
And are these the same monthly rate numbers with after the Tax Cut Jobs Act savings is taken out?
That's how I understood it.
The fourth question I had about this is...
Just to be clear, here, I mean, these are calculated based on standard rate making principles. They include the benefits of tax reform. Now, keep in mind that these rates are for year one. So if you're going to, over time, over 20 years, these rates decline because rate base declines over time. So comparing that to levelized may not be an apples-to-apples thing. It's a little different. But this is standard rate making, assuming the rate base of 2.8 and 1.2 billion, and applying tax reform benefits.
To the N&D portion, but not to the base rate portion, right?
Correct. That's right.
That's a big difference, isn't it?
Well, I'm saying, are you saying that the amortization is applied to the N&D portion? The base rates stay the same.
That's right.
Yeah.
And then the three components of building a utility rate in this case, this doesn't have the third component at all, which is the base rate non-nuclear tax reform savings, does it?
It does. That's what I'm saying. The $67 million benefit we're getting from base rates for tax reform is included in this calculation.
On the ORS and Dominion plan, we both agree, right? There's a 20-year amortization period, right?
Yeah, in the Defendant plan, we have a 20-year amortization.
And ORS and Dominion's Plan B levelized, we both agree on the beginning rate base for N&D, right? With a few more adjustments y'all made that are what, tens of millions, a couple?
Yeah, I think it's $3.5 million difference between Plan B and Plan BL, and I think Plan B and ORS had similar rate base numbers.
So effectively the same beginning rate base for N&D.
Right.
And the ORS and the Plan B levelized, we're in agreement on the cost of debt now, right?
Yeah, they're the same.
And there is a small difference in the return on equity. Y'all are at 9.9, we're at 9.1, right?
That's right.
And we all agree that 100% of the tax reform savings go to customers.
In both plans, yeah.
Right. And you've heard us say that the merger savings can be deferred and ratepayers can still get the full benefits of that, right?
Yeah, in the next rate case.
Okay.
That will be evaluated.
And so is it fair to say that it's the regulatory liabilities that get subtracted that we talked about earlier, Toshiba, a return on any Toshiba, all the tax savings from abandonment, that those subtractions are what really drives the difference between the ORS plan and the benefits Plan B alternative, levelized?
Yeah, that's right. Just want to make it clear that in our Plan B and Plan BL, we are returning the cash that is equivalent to Toshiba. I mean, the Toshiba cash is not there. We are returning cash from our balance sheet that is equivalent to Toshiba over time with a return. So that's already captured in our plan.
Sure. And let's think about that a second. There's 2.7 rough estimate for the rate base. $1 billion is for the Toshiba. It's at least a $500 million return on Toshiba. And then another $500 million regulatory liability for the abandonment tax savings, and that results in a $700 million, balance, which is what the rate base for ORS is. Yeah. Isn't that right? I mean, that's not how you created the utility rates for Dominion, but those numbers do add up, don't they?
Yeah, they sound like the numbers in the ORS plan.
Okay. And so given that Dominion's Plan B levelized and all of these similarities we just talked about, I mean, the ORS plan is at least within the zone of reasonableness, isn't it? And Dominion just prefers its own plan and the way it constructed it.
Yeah, I'm not sure what the zone of reasonableness is, but as you have heard in prior testimony, the ORS plan is not acceptable to us to move forward with this merger. But the plans we have put out here, Plan B, Plan BL, and Plan A, they would work
For Dominion.
for this merger to move forward. That's right. Yeah.
And as we keep learning more about this project, we keep getting new and better solutions. So let's look at these plans and the differences of these components. This is late filed Exhibit 153 from ORS. We talked about it a minute ago. Can you see how much of Plan B levelized is the NND only cost recovery before the tax reform savings are subtracted?
You're talking about the $8.59?
That's right. That's the Plan B levelized, right? Does that sound about right? About $9 on the average monthly bill?
Mr. Chairman, if I could just object, this is obviously not an exhibit that Mr. Pruitt prepared or is sponsoring. I mean, if he can verify numbers on it, that's great. But if he can't, then he's not the one to lay a foundation for this exhibit.
Okay. Well, we'll say if you can identify the numbers, and we can discuss them at least.
I mean, it's his plan, so let's try to do it at least.
Yeah. So the $4 benefit is or adjustment that you have here. That is the tax reform benefit just on the base rates. Right. So I'm not sure if the $8.59 includes the benefit of tax reform in there or not for the NND piece.
Right, but it would have to, because that's all that's left after you start with your monthly rate, and we know what the tax reform savings are on the base rate, and the $8.59 is actually just checking the math of your plan, isn't it? I think this came from his work papers, actually.
All right, well, maybe it did, maybe it didn't, but Mr. Chairman, Mr. Richardson is testifying here. He said it would have to be this, it would have to be this. Again, these are not numbers that Mr. Pruitt has prepared. So
but
if there's a question about whether he can verify it, that's fine.
He is the expert here presenting this plan on the final day of the hearing with 1 day notice. This is the only person we have to ask.
And Mr. Chairman, I don't have any problem at all with Mr. Richardson asking Mr. Pruitt questions about the plan. But what he's doing is asking him to verify numbers on an exhibit that he did not create. If he can do it, great. But if not, then this is improper.
Okay. Well, let's try to ask about the plan and try to verify the numbers. And if we can't, then let's don't.
I can ask him, what is the NND only portion of the typical residential electric bill for your Plan B levelized?
Yeah, excluding tax reform, I thought it was closer to $8. I don't know. The $8.59 is all I'm saying.
All right. So it might be $8. It might be $9, but it's either $8 or $9
in the range.
Thank you. And you're aware that ORS plan deferring merger savings, but with the full tax reform savings here on the far right column, results in $118.98 for the average monthly bill.
I've seen that number. I don't know the details.
Okay. You have testified about the ORS plan, and and whether it's acceptable or not. Do you know that the NND portion of the monthly bill is roughly $5.40?
Yeah, again, I mean, I didn't go in detail into the ORS plan to break out the NND and non-NND and tax reform portion, but the $118 number does sound familiar to me, the ORS plan.
Right, and you're also familiar with the difference in the calculation of the tax reform savings, the red bar, and that ORS's calculation is greater than the tax savings that's being accounted for in the Dominion plans, don't you?
Yeah, I'm aware of that. I mean, obviously, I'm not a tax expert, but I know there is some difference in assumptions and how you calculate it. I can walk you through high level of what the differences are, but obviously, you'll have to ask a tax expert for those differences.
No problem. And on the ORS plan, you recognize that it does not include the $2 a month in financing costs for the deferred transmission costs, right?
That's right. I'm aware.
And so when we look at this and just subtract the two different rates there, the difference in the ORS plan and the Dominion Plan B levelized is $6.28. Right.
Yeah, I mean, that's right. I mean, one thing I do want to highlight while you're comparing those two plans is they are generally not comparable because, as you're aware, under the 708 number assumes that the unprotected portion of the excess deferred is returned over 5 years in the ORS plan, which means rates go up in year 6. In our plan, rates for NND stay flat for 20 years. So it's not an apples-to-apples comparison.
Except you know that the ORS plan is also levelized. That's where you got your idea, wasn't it?
We definitely got the idea, but different methodology.
Yeah. And as far as the customers go, this is the way that they'll compare the plans, is what they pay on a monthly basis, right?
Yeah, but again, I mean, rates in the ORS plan, the bills will go up in year 6.
You don't think the ORS plan is levelized?
I'm not sure if it's levelized from return of the tax reform benefits perspective.
Okay. Now, the net present value difference in Dominion's Plan B levelized, I think you said is 962, and do you know that ORS's net present value is 782?
Yes, I'm aware.
Okay. And you didn't get any different net present value number for ORS's plan, did you?
I didn't calculate any for that plan.
Okay. But basically, the 782 net present value for the ORS plan over 20 years from ratepayers for these NND recovery is not enough merger economics for Dominion, but the 962 is?
Yeah, we're willing to move forward with Plan BL. The way we have designed these plans is we can make all of these work.
And so that's the real difference here, right? It's the $180 million in net present value between what Dominion wants from customers to get its merger done, right?
I mean, again, there's the ORS plan has a different NPV. We have a different NPV. I don't think NPV is the only metric to look at what plan is better and which one is not. But yes, the difference is $180 million.
Let's turn to your Exhibit 4, the merger commitments and conditions that are from Dominion at this point. And Exhibit 4, correct me please if I'm wrong, contains language and terms including those requested by ORS and interveners, doesn't it?
Yeah, some of the conditions have.
But not all of the ones that ORS and interveners wanted, did it?
That's right.
Okay, let's look at just 3 issues with the merger conditions from Dominion. First, it's clear one thing that's missing is this code of conduct, even though Dominion is subject to a code of conduct in North Carolina, right?
Yeah, I'm not aware of details of the code of conduct in North Carolina. Or I'm not familiar with it. I'm sure it's there.
Okay. But you're familiar with you've been a witness already in this case, and you would agree that under the evidence we've had in this hearing and the circumstances of this project that the company that Dominion's proposing to run, that it wouldn't be unreasonable to have the same or similar code of conduct provisions here in South Carolina as Dominion has in North Carolina, would it?
Yeah, again, I can't comment on that. I'm not an expert on that, so.
Okay.
All right.
Let's look at the second merger commitment and conditions issue. Mr. Farrell told the commission that the CEO of SC&G would report directly to him. Do you remember him saying that?
Well, my understanding was he said the CEO of the Southeast Energy Group, or whatever the name of the subsidiary is, will report to him.
All right. Now, yeah, we're reading that now, and that's why we're talking about it. The most recent merger conditions is that the SC&G CEO will report to the CEO of Dominion Energy's Southeast Energy Group instead. And who is that person?
I don't know, and I don't think I can opine on that. Those decisions are made by the board.
Okay. On page 3 of Exhibit 4, the first commitment under the affiliate transactions talks about Dominion Energy does not permit the lending of cash or other capital from a utility subsidiary to any other entity within the Dominion Energy family. But that's not really a commitment, is it? If it were a commitment, it should read Dominion Energy shall not permit any lending of cash or capital from SC&G to any other entity within Dominion Energy family, right?
I'm sorry, I'm not a lawyer, so I would defer to counsel for that.
Okay. And we talked a little bit about you getting some of these terms and merger conditions and commitments from ORS and interveners, but you saw what the merger conditions requested by ORS and interveners, didn't you?
Yeah, I've seen it. I'm not intimately familiar.
All right, and I'm not going to ask you about them, but Mr. Chairman, I would like, given the unique nature of this new witness and in the proceedings and in the interest of us not calling a separate witness, we'd just like to enter into the record for the completeness of it, the merger conditions from ORS and the interveners as the next hearing exhibit.
It will enter it as Exhibit 171.
And again, I'm not going to ask you about any of those specifically. They can be accessed by anybody, but those are the conditions.
Mr. Chairman, I'm sorry to interrupt, Mr. Richardson, but may I ask a question? Mr. Richardson, are these the merger commitments and conditions as contained in the testimony of witnesses, or is this just something that ORS and the interveners are saying we'd like to have at this point?
This is what I believe Mr. Probir, in offering his new terms and conditions today or yesterday in the testimony, took some but not all of the request of ORS and the interveners. So we thought it would be only fair to have a complete record of the things that Dominion picked and choose what they'd liked and what ORS and the interveners have said that they would like.
Okay. I guess my question was simply, Mr. Chairman, was this something that is just a compilation of things that are already in the evidence, or is this something new?
Yeah, where did these come from?
They are a compilation of merger terms and conditions requested by ORS and the interveners.
Was it in testimony or?
I don't think all of them are in testimony, and I think we could bring a witness to put them in. But again, I know that Mr. Probir looked at them. That's why we were offering through him. They've picked and chosen which ones they like. We just want them all in if that's the way they're going to present it here at the end of the 11th hour.
But Mr. Chairman, our list is based on the evidence in this case. And I know Christmas is in a month, but if this is just a wish list that they want to put in that's not based on the evidence in this case, I think that's improper and I would object.
Are all these in the record somewhere?
We want to be sure that they are, and I think if we can't just have them entered in, Mr. Chairman, we'd ask for leave to call Ms. Dawn Hip to introduce them into the record.
Well, Mr. Chairman, just looking at it, I mean, these are not based on the evidence. These are just some conditions that at the 11 and a half hour that ORS has come up with.
Yeah.
I see several that are clearly not in the evidence, and I don't think it would be appropriate without testimony to have supported it during the hearing to have a witness at this point come up and say, we've come up with some new things that we want the commission to consider. We haven't had.
Well, that's exactly what we're doing right here, right now.
No, to be clear, Mr. Chairman, this is a compilation of what is already in the record as ORS requested. They asked for it to be put in one document, and at their request, that's what Mr. Pruitt has done, to compile the commitments by the joint applicants, which are contained in the pre-filed testimony, with the exception of the new commitments that were based on questions and suggestions from the commissioners, which are clearly laid out. It's very different from what you see here.
Mr. Guile.
Mr. Chairman, I support the ORS request that this be included as an exhibit in the record. I just would submit that it's a matter of argument that I believe is well supported, that these proposed merger conditions are supported by the evidence of the record, in the record, from a variety of sources. Now, we were indulgent with Dominion in essentially springing a supplemental rebuttal witness on the last day of the hearing at the 11th hour, but it's in the nature of a pleading. I mean, they're basically saying, here's a pleading, here's our relief that we're asking you to consider. We're interested in hearing that, and the witness has so testified. But I believe in fairness, the ORS and other intervening parties that cooperated in producing proposed remedies in the form of merger conditions have their consolidated supported merger conditions presented in like form, and that is as an exhibit to the evidence. And let the parties argue about the legal basis or the evidentiary support for those conditions in our final orders. The alternative remedy I hear counsel for ORS suggesting is offering a witness to sponsor, but I believe that's just a waste of time. I just think you should take the merger conditions as an exhibit as they were represented by ORS counsel.
Do you have something else, Mr. Richardson?
Support what Mr. Guile just said.
Okay. Mr. Reed?
No, I think my position is clear.
Okay, after talking with Mr. Butler, you just don't think there's any basis in the record for this, so we're going to have a witness to talk it through, to put it in the record. We can't put it in the record if there's no basis for it.
Mr. Chairman,
We can say where.
I mean, most of these are supported by the record. I think that there may be some that had not been previously introduced, just like the Plan B levelized wasn't introduced until today. But we're happy to put her up. All she's going to say, we've compiled them and we provide them to the other side, and we want them to be considered by the commission if it so chooses.
So, Mr. Chairman, if I may be heard for one moment, Dominion and the joint applicants would have no opposition to a late-filed exhibit, a revised late-filed exhibit that is actually based on matters that are in the evidence, a compilation of merger commitments suggested by the by the interveners in ORS that's actually based on the evidence. But that's not what this is, and I'm not sure that having a witness appear to say this is something we want that's not based on the evidence is sufficient either. So,
we think that's pretty consistent with what we're doing right here today. But I will say this, Mr. Chair, I think we'd like to have it considered, and so if necessary, I think we're just going to disagree as to whether it's supported by the record. Mr. Giles already said it's supported by the record, And so it's going to be what we file, late filed, and then they're just going to argue about it, and we're going to be out of the hearing. So we either can have the witness present it or not, but I think we want to move it in.
I just would say that these merger conditions have no less status than the merger conditions that this witness has just sponsored. They may or may not be legally supported. They may or may not be supported by a preponderance of the evidence in the record, and that's for you to decide. But I believe they're in the nature of relief requested, just as the Dominion merger conditions are. And so I just disagree with counsel for Dominion that somehow they're of lesser status, or that we should be picking and choosing conditions, citing to the record at this stage. They didn't do that. So I just would say that at the 11th and a half hour now, whichever is the most efficient way for the commission to consider this without belaboring the point, we ask that you take this in and allow us to brief it as part of our proposed order.
Okay, I think one difference is, of course, Mr. Pruitt presented the conditions as shown in his testimony. We don't have any testimony to show that I'm aware of the merger conditions as presented in what we've marked as 171. So I think what we're going to need, Mr. Richardson, is Ms. Hipp or whoever you want to put up. If you want to put them into evidence, I think we're going to have a witness. So at least that way they'll be on equal evidentiary footing. People can ask questions if they want, but I think you're going to need a witness to do it.
And I think I remember Mr. Pruitt not even being able to answer the questions about several of the conditions that I asked him about, but we'll certainly do it, put it in with Ms. Hipp.
All right. Thank you.
Can we agree that the plan that we need to find in this case is the experimental rate for the NND recovery? And isn't that really what, in fact, y'all are a little bit under it?
That's what we tried to achieve.
Okay, and that we also have to have a plan that delivers all the tax savings from abandonment and from the tax reform in order to be just and reasonable here.
That's right, but I'm not sure if you're comparing that to the experimental rate.
Right, and doing those two things, experimental rate for NND recovery and then all the tax savings, that's the ORS plan at 118 and 98, isn't it?
Sorry, are you saying that the you're adjusting the experimental rate for tax reform?
Oh, you can see right up here, right here. Experimental rate doesn't have any tax reform in it right now, does it? Because it hasn't been implemented yet.
Yeah, I mean, not clear to me, but the experimental rate also doesn't have any amortization. That's one. The second thing the experimental rate doesn't have is the financing cost of anything over $1.2 billion. So it's not something it's not apples to apples.
But if we wanted, the commission wanted to provide the experimental rate for the NND cost recovery and all tax savings, that would be the ORS plan at 118.98, wouldn't it?
I'm not sure. I don't think so.
No more questions.
Thank you. Other cross. Mr. Knapp.
Thank you, Mr. Chairman. Mr. Pruitt, I'm Frank Knapp. I'm a pro se intervener in this matter. I don't believe I've had the opportunity to chat with you before. Do you agree that the Plan B, do we call it Plan BL or B-L?
Either is fine.
Okay. Plan B-L would roll back rates by 15%, which equals the rollback in the experimental rates?
Yeah, slightly lower, but yeah, approximately.
Good. Thank you. Do you know how the South Carolina General Assembly landed on their experimental rates?
I'm not sure how they landed on that.
Okay. Do you have any reason to believe that the legislature first picked 15% as the rate cut and then figured out how to get there?
I don't know, so
All right, thank you.
go with that.
We'll go with that? So you're speculating that they wanted 15% and then worked their way backwards to get there? You think that's what they did?
Yeah, I mean, again, I don't have background on that, so I can't answer.
Okay, so I can't answer. Thank you, sir. Did the legislature in their act, which was House Bill 4375, use any benefits from the 2017 Tax Cuts and Jobs Act in its determination of what the experimental rates should be?
Again, I don't know how they arrived at the rate, so I don't know if it has the benefit or it doesn't.
Okay, thank you. But Plan B-L does include some of the benefits of the Tax Cuts and Jobs Act, correct?
That's right. It includes all of it.
All of it? Okay, well, let's get to that. Oh, what is that percent? And I will caution you that I'm on very trembling ground when I start talking percentages and numbers.
And Mr. Knapp, we've just gone over all of this, so we need to get to something new.
I'm getting there, Mr. Chairman. It was 2.7% then. Is that correct?
2.7 on the base rates and another percent on the new nuclear, so a total of 3.7.
Okay. Do you know what utilities across the country have been already passed on the benefits of the Tax Cut and Jobs Act? What their numbers are using to their customers?
I'm not sure.
Okay, so we have no idea how your proposal compares to other states.
It's hard to compare the benefits of tax reform across various jurisdictions because there's a variety of assumptions that go into that. Specifically, what the last rate case was, whether they have a rider like NND or not, and there's a lot of things that go into that detail. So I'm not sure you can compare the tax reform benefits of one utility versus the other without accounting for all those assumptions.
But you did come up with 2.7%.
On base rates plus 1% on the NND, so 3.7.
That was
total.
without the benefit of knowing what other states might have done.
Yes.
Thank you, sir.
Just to clarify, I mean, our tax experts will probably know all that, and they were available for questioning earlier.
Well,
Witness Jim Warren.
This is a new offering. B-L is new.
The tax benefits in B-L are no different than Plan B.
Okay, thank you. Do you know if Dominion passed on any tax cuts due to the Tax Cut and Jobs Act to their Virginia customers?
Yeah, I'm aware they did.
Do you have any idea what that was, that percent?
Yeah, I don't know the magnitude of that.
Okay, thank you. All right, so, and here's where I really, and we talked about the 2.7%, and I think that you've already tried to explain how we came up with that 2.7%. But in reality, that's not what you anticipate it being completely, or is it? In the base rate. Do you expect it to be higher in the second year?
On the base rates?
All right, how about the NND, the 1% on the NND?
Well, let me clarify. The 2.7% on the base rates stays relatively flat. I mean, there is a return of 2018 collections that would, I don't know if you're talking about that. On the NND portion, the impact of tax reform depends upon how the deferred tax asset is used over time. So it fluctuates. The details of that those are probably better questions for a tax expert.
All right, so that 2.7 will never change as far as you know on a base rate.
I mean, it will change, but I don't know if it will change materially. But
all right, but you could. Do you think you could have figured out a way to get that to 2.8% on the base rate?
Not in my opinion, but again, that's the question for a tax expert.
Okay, thank you, sir. If the legislature, we're going to assume, because you do not know the answer to this, that the legislature did not include any of the tax benefit from the Tax Cut and Jobs Act in their deriving of the 15% experimental rates, had they done that and used your numbers, at least the 2.7%, would that meant that the experimental rate would have ended up being 17.7%?
I would object, Mr. Chairman. Ms. Pruitt's already said he doesn't have any idea how the legislature came up with its rate.
Sustained.
Okay. But you have already testified in your opening remarks that you wanted to get to that experimental rate.
That's right.
Okay, so you did what you needed to do to get to that experimental rate.
That's right.
Okay, so you picked a number and you worked till you finally figured out how to get there. So did you hear my questions of Dominion CEO Tom Farrell?
I heard them, yes.
Oh, thank you.
I don't remember all of them, but I heard them, yeah.
I asked Mr. Farrell, if you remember, about the original customer benefit plan and Plan B, and he said that the plans were basically the same, just distributing the customer benefit differently. And I've heard testimony from you that's basically correct.
That's generally correct, yes.
And does that basically mean that if the original customer benefit plan and Plan B are basically the same plan, just finagling the customer benefits differently, that would also pertain to Plan B-L?
Yeah, it's a different way to allocate the benefits to customers.
Okay, all right. So we're basically, if they're all the same plan, we're just rearranging the chairs.
Generally, yeah. But if you look at it, the total amount of cash that was being given back in Plan A was about $1.875 billion. In Plan B, it was $1.91, and in this plan, Plan BL, it is $2.039. So there are some differences, but if generally, yes. But Plan BL gives a little more cash, although over time.
Thank you. Where did you get that extra cash?
I'm not sure I follow.
Well, you just said that the cash going back to the consumer is different. I'm just curious of where the extra cash benefit to the consumer came from. What did you change to get the higher number?
Yeah, again, it's a different model, right? In the model that we look at in terms of customers, in terms of Dominion, in terms of shareholders. We tried to balance all of that in coming up with the plan. So in case of the $130 million, it's coming from shareholders.
Okay. Well, thank you.
Yeah.
Thank you. So if you wanted to get to that 15%, you could have asked the shareholders for just a little bit more if you needed more.
Again, that's in order for us. In order for our responsibility to our shareholders, our fiduciary responsibility, we need to make sure that in the merger economics work here. So if that doesn't work, we can't achieve this plan.
Thank you very much. I appreciate it. I'd like to show you a statement by Dr. Glenn Hubbard that he gave in his summary of his direct testimony, if we can see that. Oh, thank you. Yay, testimony. Can you see that, sir?
Yeah.
The underlined portion.
Yes.
May I read it, and you can tell me if I've read it correctly?
Sure.
Sure. If the experimental rate becomes permanent, SC&G would suffer hundreds of millions of dollars in additional lost revenue, which would have a larger negative impact on SC&G's financial condition, credit rating, and cost of capital. Did I read that correctly?
Yes, that's what it says.
I then asked Dr. Hubbard that if the company, SC&G, Dominion, wouldn't be committing financial suicide if they would agree to take those experimental rates. And do you remember what his answer was?
I don't remember.
He basically said no. He said that suicide is too hard a word. And because he said it's really a business decision. That there are other factors in making a business decision. Is that correct? Other than rates? And it wouldn't be on there.
Sorry, can you repeat the question?
I'm simply asking, in making any business decision, it's not just about what the rate is. It's other factors go into making a business decision, correct?
Yeah, there are several factors.
Okay, thank you, sir. So it's not just rates, and that's why Dr. Hubbard said, no, it wasn't a financial suicide to do that.
Well, without taking into account the full package and what all the other factors are, you can't say that this one factor decides everything, right? Whether it's yes or whether it's no.
Right. Thank you. I appreciate that. So there are other factors go into a business decision. So if this commission ordered rates to be reduced by more than 15%, say the 18%, or even ORS's proposal of about 20%, there were other business factors that could lead Dominion to still want to complete the merger with SCANA. Is that correct?
They could, but without knowing any of that today, can't comment on that.
Good. Well, thank you. Well, you answered, I think, correctly that it could. Changing subject real quick, and this is my last thing, Mr. Chairman. You, in your second supplemental rebuttal testimony on page 8, if you have it handy, I would like to look at it. It was what was passed out, I believe, a little while ago. That's it. That's the page. And in that copy, and I've heard this before in testimony, that there is want to be some recognition that the new proposed Plan BL, in fact, even the Plan B rates are now close to being average with other SC&G pure South Carolina utilities. Also gets residential rates down to something that's comparable to others what are paying from other utilities at the South Atlantic average. Even the customer benefit plan would be about 2.5% above South Atlantic average and about 15% below the South Atlantic average for the industry. And I know that is introduced obviously is to show that this is really a good fair rate that you're proposing, correct?
Yes, the Plan BL rate.
Right. But this isn't the model that this commission should use in the future for setting any rates by looking at what everybody else is doing. Should we be doing that?
Mr. Chairman, objection, relevance. I think we're getting far beyond the scope of Mr. Pruitt's testimony.
Sustained.
Thank you very much. No more questions. Thank you very much.
Thank you. Any other cross? Mr. Anselmo.
Thank you, Mr. Chairman. Michael Anselmo on behalf of the Speaker of the House. Good to see you, Mr. Pruitt.
Good afternoon.
And I'm going to hit a couple things I need to clarify, but hit the highlights of some things it appears that Dominion still agrees with ORS on in regards to these rates. First thing, just like in Plan B, Plan BL has the same abandonment and disallowance date of March 12th, 2015.
That is correct.
Right. And actually the rate base in Plan BL is the lowest between the ORS optimal plan and Plan B. It's $2.768 billion now.
That's right.
Cost of debt, you adopt the ORS level.
That's right.
20-year amortization period, just like ORS.
That's right.
First time y'all have ever asked for a return on equity under 10%.
Yes.
You're deferring $332 million in transmission costs, just as ORS requests to a general rate proceeding in the future. You're keeping $32 million in, but there's an additional $332 or $322 that's deferred till later.
Yeah, we're keeping the 32 financing costs, but capital, the return off capital for the entire 322, and then the financing cost of whatever is not in there, we're deferring. That's right.
And then as far as the customer refund and restitution, I think you and I discussed last time we talked that the customers to date have paid about $2.1 billion in financing costs for the project.
Including transmission, that's right.
And the restitution package in Plan B was approximately $1.91 billion, which if you read a letter that's been talked about a lot, that's about a 90% return of those monies to the customers.
That is correct.
And now Plan BL goes to 2.039, which is approximately 97% back to the ratepayer in nominal dollars.
Yeah, I haven't calculated, but yeah, that sounds about right.
All right. Now let's talk about the rate itself for a second. And there's been obviously lots of discussion on the Trump tax cuts, the TCJA. I believe you testified earlier that the ORS calculation, if that number is adopted, would cause rates to increase after year 5. Is that correct?
That's my understanding.
Can you explain why that is?
Yeah, because the return of the excess deferred portion that was collected in rates needs to be returned to ratepayers, and generally, or at least in our plan, it is returned over the remaining average life, which we believe is more consistent because customers are paying for the depreciation over that time too. In the ORS plan, it gets returned over 5 years. So after, in year 6, that adjustment is not there, so rates go up.
So the BL plan would alleviate the rate spike in that year and pass through the full amount of the tax cuts. I think you said 3.7%.
Yeah, 3.7 is what we have calculated now.
And were you able to listen to the testimony from Mr. Rooks yesterday that he provided about the experimental rate and the amortization period?
Yeah, I didn't fully listen to it, but generally familiar with
the concerns therein. So Plan BL actually alleviates those concerns by how y'all amortize the debt as well as pass through the tax cuts, correct?
I believe so.
And y'all also adopted the levelization plan proposed by IRS to get this rate to the 125.26.
That's right.
And that rate now brings South Carolina really in line with the South Atlantic states for all individuals.
That's right.
Yep. And for utilities, we're talking a rather substantial increase, right? Or decrease.
Yes.
What was that amount?
Sorry, between the current rate and
the proposed BL rate and the current rate for the industrials, isn't that about a 15% reduction?
Yeah.
Now, I know y'all have testified this. Dominion is going to walk if the ORS optimal plan is adopted.
That's right. That's what we have.
Would Dominion close the merger if the Commission enters any rate lower than the BL rate, but north of the optimal plan for the ORS?
Yeah, for now, those are the three plans we have on the table.
Gotcha.
That we're willing to close a merger on.
If Dominion walks, can South Carolina Electric and Gas provide any of the benefits under Plan A, B, or BL to ratepayers as a standalone company?
Not in my opinion.
And can South Carolina Electric and Gas survive without financial consequences to the ratepayer at the ORS optimal rate?
Yeah, I mean, I think Witness Chapman talked about it in detail. I think it will stress their balance sheet significantly.
So really the ORS rate is illusory because E&G can't implement that. Would you agree with that?
I would agree with that.
So really the only way to give long-term rate relief and certainty to ratepayers is the adoption of one of these plans, especially Plan BL?
Yeah, we believe so. I think that'll be the best outcome for all of us.
Is there any reason, Mr. Pruitt, in your opinion, that the Commission shouldn't adopt this plan?
No, I don't think there's anything.
Yeah, the Speaker doesn't see a reason either, and we ask for it to be adopted.
Thank you.
Thank you. Other cross. Commissioners. Commissioner Elam.
Good afternoon. I want to look at the late filed 152. This is what I requested yesterday, and I'm not certain we're really on the same page. Part of what I asked for, do you happen to have late filed 134, which was behind a letter sent on November 19th from Mr. Burgess, and included an update of this chart?
Yeah.
You see that?
I don't have it. Is it similar to the chart on page 8 in my testimony?
I have many things right here right now. Yes. Page 2 of that. Part of what I thought I asked for, anyway, was a recalculation of the rates of each of the plans on the page if you used a 9.1 ROE.
Understood. Yeah, I wasn't aware of that.
Can you supplement 152 to do that?
Yeah, we can calculate it.
You want to supplement that one or just add another one? New. Okay.
Okay, we're going to ask for a late file supplement to 152, and we will enter that as Exhibit 172.
Can I ask a question on one of these plans, especially the H4375?
Doesn't really have an ROE attached to it.
Right.
You can leave that one out.
Okay. And the column right next to it as well, I guess.
Yes, the H4375. I agree with that. Give me a second. I don't know where I put everything. No. He may get me.
My granddaughter encouraged me to keep my smiley face on, so.
Okay. I'm looking for your testimony that was filed, and I don't seem to have it in front of me anymore. No, excuse me, I got it. All right, your testimony. I got you. Damn the torpedoes. Page 12 of your testimony. I'm trying to understand, in some of these bullet points, you talk about things not being included in cost of service, and in others you say not included in any future cost of service. Is there a distinction between those two, or as an example, the Rabbi Trust, future cost of service, cost of the Bechtel report just says cost of service, as does the Timmerman consulting payments. Is there a difference between not included in cost of service and not included in future cost of service?
Yeah, I think, sorry. Again, I'm not intimately familiar with all these commitments. This testimony was merely consolidating what we had agreed to in other parts of the testimony here. So I'm not an expert. That said, I think on the future cost of service, I mean, it's pretty clear. We don't know in the Rabbi Trust what's in or is not. As personally, I mean, I'm really not familiar with that at all, the Rabbi Trust, so I can't answer that.
Okay, might some of it mean that it's already been expensed in a prior year, or I'm trying to figure out the distinction.
I apologize. I'm not sure what's in the Rabbi Trust and how it was expensed. So,
okay. The civil litigation defense expenses, the bottom bullet point. I believe you were already asked about this a little bit, whether that included criminal litigation. It's been discussed that there is I guess, an insurance policy that is covering attorney's fees for employees. Is that correct?
That's what I heard.
Okay. And that's what's paying the costs now, as opposed to the company paying those costs out of its revenues. Is that correct? Don't know?
I'm not familiar with that.
Okay. Does part of the commitment not to have civil litigation defense expenses include not having the expense for the insurance policy?
Yeah, I'm sorry, I can't answer that question. I'm not familiar with that.
Okay. The 4th bullet point, bill credits to SC gas customers. You see that?
Yes.
What is that from?
Again, this is we are providing, as part of all these plans that we proposed, all the benefits that we're providing was to SC&G electric customers for the NND. What we have done here is consistent with what we have done in North Carolina. We have added a similar amount of bill credits for SC&G gas customers.
How is it based? Is it just for tax Cut Jobs Act or something more than that?
No, this is more than that. Tax Cuts and Jobs Act will be passed through to all customers, the
Okay.
full amount. This is in addition to that.
Okay, so you're basing the electric givebacks on some I don't know if it's a peak usage in a 2016 or something. How are you doing that for the gas customers?
I don't have the details of exactly how it's going to be implemented, but the dollar per customer that we're providing is going to be similar to what we provided in North Carolina. I don't have details of the exact calculation of how it goes to each customer.
So you don't really know what happened in North Carolina with that?
Yeah, I wasn't part of the North Carolina proceedings.
Do the merger conditions require that SC&G file a general rate case on May 1st, 2020, based on test year ended December 31st, 2019,
That's right.
even if rate relief isn't needed?
That's right. We have a comeback. And just to be clear, in the test year, it'll be filed with the end of 2019, but we'll update it for known and measurable expenses until September 30th of 2020.
Okay. On page 4 of Exhibit PP-1A attached to your testimony today, it states that a refund of tax savings for the period January 1, 2018 to December 31, 2018 will be flowed back to customers through a one-time bill credit, correct?
That's right.
And that will be in addition to the bill reductions calculated under the alternative levelized plan.
That's my understanding.
When will customers receive the credit?
I don't know exactly how we awarded it. I think it'll be in the beginning of 2019.
Okay.
In the first half, I'm pretty sure.
And lastly, I think what I've heard from Dominion is they're sort of agnostic to, whether money is refunded up front or it's spread out over bills in the future. And is my understanding correct?
That is generally the difference between Plan A and the other two plans we have offered, but it has to be in a certain
proportion.
Not just proportion, but also in a certain way that we have crafted these plans.
Okay.
So there is some sensitivity there.
Could you craft a plan that was part refund and part lower bills going forward?
I'm sure we could come up with a plan, but again, it would require approval from senior management. And
Understand.
Yeah.
And I'm not committing you to anything, but I would ask for a late filed exhibit. And while we're at it, where you go half and half between refund and rate reductions, and 25, 75, 75, 25. You understand what I'm saying?
Yep.
Okay.
That will be hearing exhibit 173.
We like options.
We're almost to 200 too.
Yeah.
You want me to think of 27 more?
Not unless you want this thing in your ear.
No further questions.
Yeah, just
That's cute.
one thing, just to clarify on the request, we'll have these options, but if we give more cash up front, it does increase the bill.
I understand.
Okay.
We just want to be able to see, if you did that, what the resulting bills would be.
I understand. Thank you.
I guess as variants of BL.
I understand. Thanks.
Commissioners, other questions? Commissioner Irvin.
Thank you, Mr. Chairman. I understand that both the North Carolina Utilities Commission and the Georgia Public Service Commission have approved the proposed merger. Did you submit similar terms to them in terms of did the order contain contingencies or anything like that? Or is it possible we could get a copy, a late file exhibit showing us a final file copy of that order, counsel?
Yes, Judge, we can certainly submit as a late filed exhibit the approvals in Georgia and North Carolina.
Thank you.
There'll be Exhibit 174.
And counsel, while you're standing, I wanted to ask you, rather than requiring ORS to put up an additional witness, would you consider the merger commitments and conditions in Exhibit 171, this marked for identification, to be a pleading that in a final order would have to be supported by specific citations to the record so that we could consider it as a request only and not not a part of the record, but a request that has to be tied back to the record? Would you agree to that?
We would not have any objection to the exhibit being amended to only include those conditions that are supported by the record.
Because there would have to be, and otherwise it wouldn't be proper.
And I don't want to waste time or embarrass Ms. Hipp, but I mean, there's a whole mess of them that aren't supported by the record.
And you'll point that out to us, I'm sure, in your proposal order too, if it need be. But would that be agreeable with you?
Absolutely. We agree with your suggestion and don't intend to offer anything that's not already supported by the evidence. And we were going to use Lane Colon, for example, rebuttal Exhibit 8 to show that the vast majority of them are already in evidence.
Thank you.
So I'm clear, Mr. Chairman, is this back and forth. ORS is agreeing to amend this exhibit to only include those merger commitments that are supported by the record with a record citation.
That is not what we agreed to, although, because I think we're just going to disagree about what's supported by the record. And I think doing it in the proposed orders is the appropriate place. And we offer it as a pleading, a specific request to the Commission that is, of course, not supported by the evidence, wouldn't be included in the order.
Okay. So it would be, any merger commitment request would be in ORS's proposed order with a citation to the record, and this would not be an exhibit that's admitted to the record. We don't have any objection to that.
Okay. I keep resisting getting assignments from Mr. Reed. I think he's given me enough work, but I do think that the spirit of that is correct, in that we are not offering this as an evidentiary exhibit. We're offering it essentially as a pleading and a request that only if supported by the record already, or in the evidence already, would it be a proper request to the Commission.
So it's been marked for identification, and we don't have any objection to it being marked for identification but not admitted to the evidentiary record.
Got that solved with everybody? Okay, thank you. Other commissioner questions? Any redirect?
No redirect, Mr. Chairman.
Thank you.
Mr. Chairman, may I just ask one question?
With respect, I think we passed all that, didn't we?
Well,
but you have to be with your mother-in-law.
Yeah. Don't remind me.
And if whoever's watching on live stream, that was Scott Elliott.
My family long ago stopped watching. I'm safe. But my only question, really, of the chair is on late file exhibit 173. It's half and half, and then is it 75%, 25%, and the other way, 25%, 75%.
Right.
Okay. Thank you.
Mr. Elliott, we just got a note that your wife is holding on line 2. I'd like to speak with you. It's a matter of urgency. Relates to tomorrow's plans.
Well, in that regard, may I ask a few questions of this witness?
No. Yes, sir.
And may I ask that our rocket man here be excused?
We will. Thank you for being here and for your testimony, and you are excused.
Thank you.
Mr. Burgess.
Mr. Chairman, we don't have any other witnesses to call, so that would conclude the joint applicant's case in chief. I did want to bring one matter to the Commission's attention. While I was sitting here at 2:12 today, I received an audit information request from ORS, and I've got copies here that I can pass out to the Commission where they were inquiring of SC&G into the pre-filed and sworn testimony of Wade Richards. I would ask that this Commission strike the audit information request that ORS has sent to us. ORS conducted a full examination, cross-examination of Mr. Richards. They had every opportunity to ask him questions with respect to his testimony therein. So I'll be happy to pass these up, and I would ask that you instruct ORS to withdraw this request, or in the alternative, you grant us relief that we are not required to respond to this data request.
Okay. We need to hear from ORS on that.
Mr. Chairman, and I apologize, I'm not sure I have a lot of information about this, but we feel like this is a necessary request in order to address concerns that have been raised to us anonymously that, at least for now, let it suffice to say, are very disturbing, and if true, would raise some serious credibility issues with testimony that was provided during this hearing. Now, I certainly hope and don't know any verification whatsoever of any of this information, but this was not sent lightly and was intended to verify that those suspicions are unfounded and that there would be nothing else to be submitted in this hearing. And so I think that's that our request is that it would only be in these extraordinary circumstances that there would be anything more for the Commission to do other than to simply not preempt this inquiry.
Mr. Balzer.
Mr. Chairman, may I make a suggestion, since we had not been informed of any concerns regarding the testimony before this ARR showed up on our inbox while we're sitting here, that we confer with the Office of Regulatory Staff, have them disclose to us what it is they're concerned about so that we can look into it and then hold this ARR in abeyance until we have an opportunity to at least confer with them. We have no idea what they're talking about.
We consider the audit information request not only proper under the statutes, but also the inquiry that we're trying to make. I think that it's going to be very difficult for us to confirm or satisfy this concern that's been raised to us without some kind of response to this.
Again, we have no idea what we're looking for. I mean, presumably the testimony that was submitted was done so with an understanding that it was true and accurate. If they have reason to believe that it wasn't, they should tell us, not now on the record since it's unsubstantiated, but privately what it is they're concerned about, and let's look into it.
We're going to take a 10-minute break.